Welcome to the Zealous Advocate Podcast. Join attorneys James Moore, Kevin Littlejohn, and Mysty Blagg as they explore law, technology, and persuasive arguments. Sit back, relax, and listen to your zealous advocates.
Welcome back to the Zealous Advocate Podcast. We're happy to have you join us on our journey to explore advocacy. Today, I have my co-host here, Kevin Littlejohn and James Moore, and we also have a wonderful guest joining us, William Wright. Kevin, if you could introduce William to our audience.
Yes, good afternoon, good afternoon to you. Misty, I hate that you can't be here in the studio with us today. It's always a pleasure to sit beside you and navigate these issues. But nonetheless, I'll proceed forward in introducing our guest for today, who I'm extremely excited to have at the table with us. We have none other than William Wright, who is one of the partners here at Shipman Wright, who is a Wilmington native. Attended the University of North Carolina at Wilmington, ultimately transitioned on to complete his Juris Doctor at none other than the Norman Adrian Wiggins School of Law, which is Campbell University School of Law. He's been practicing here in Wilmington, North Carolina for quite some time and has an extensive background through all phases of civil litigation. Aside from his legal abilities, he's also a well-rounded man. He enjoys surfing, a family man, enjoys music. I'm looking forward, in fact, to going to a concert with him on Thursday. So I'm excited to have Mr. William Wright join us on the podcast here today to discuss his expertise and the lessons that he's learned over his career as he's advocating in different jurisdictions in different courts. So, Mr. Wright, good to see you. How you doing?
I'm doing good. Thanks for having me.
Oh, man. Thank you for joining us today. So
I felt like that was a little bit of sucking up.
every time I say anything about anybody, I'm sucking up.
I mean, Misty, that was the longest intro.
I mean, you're kicking me under the table and everything. I'm like, what is going on? I mean, Lord. So
seriously, William, we're so happy to have you here today. What we like to do in the beginning is a quick recap of our previous episode. And on last episode, we had John Lindsay, and we had just some fascinating conversations with him. He is president of Insight Legal Tech. Kevin, what was your best takeaway or the conversation you enjoyed most with John?
I enjoyed the entire discussion with him. I was really captivated by that digital twin discussion that I think you and him were kind of having. I thought that was really, really interesting to learn that there are ways that companies can be more efficient, I guess, in troubleshooting issues by creating a digital twin of some sort of, I think the way that he worded to us was like a turbine or fans and things of that sort. And translating that to the legal field and learning how or if that could be done with respect to judges' perspectives, the way judges lean, the way jurors lean, was a very, very interesting conversation. So that was one thing that I really appreciated.
I agree. I got really stoked about thinking how we can transform legal education.
You were nerding out.
Imagine if you're a lawyer in practice and you just wanted to brush up on your trial skills, because we don't go to trial very often anymore.
Right. No.
How about you, James?
Yeah, I agree. The digital twin, that was probably the one that was the most impactful to me. But just overall, the importance of AI, not only in the legal field, but everywhere, how big it's becoming. And what I took out of that was you better adapt to the change or you're going to be left behind. So, everything that he was talking about, the integration, the fact that you do need the right people in place to make sure that the technology, the AI is working, is integrated with whatever, data that you have available. I thought all of it was intriguing. And I think we ultimately need it.
Yeah, I do. And we were actually discussing this when we were talking about sort of what has taken the legal field so long to sort of embrace AI and the different capabilities of technology. And I hate to say this because I'm not by any way insinuating anything, but one of the things was we thought the older practitioners in the law sort of were a little hesitant to embrace AI and technology with respect to their brief writing process, things of that sort. And so, what's your take on using AI and the development of technology as you're, litigating cases or working on cases? Do you see a benefit for AI?
Absolutely. When I first started practicing law, Westlaw was just coming around and Lexis was just coming around. And, I was trained on the books. You went to the books and you found the digest and you found the cases, and then you went and pulled the book off the brown books for the Supreme Court and the green books for the Court of Appeals. And, it was slow, time consuming. And Westlaw, I can remember the day I learned to cut and paste a quote from Westlaw, and I thought it was the greatest thing on the planet. I was like, oh my God, I don't have to type, 3 paragraphs. I can just cut and paste it and do it in a second. And now we've got AI that you go all the way. You can write a brief and it'll pull out the quotes from your documents that you've gotten or your depositions that you've gotten and plug them in. And if you cite a case, it'll make sure that that's still good law and make sure that your pinpoint cites are correct. And so much time consuming that ultimately makes us more productive, saves money for our clients. And, I understand older men, especially, I hate to be sexist about this, we're resistant to change. And,
James says the same thing.
It is.
Said the same thing.
It's hard. My wife's like, and in my personal life, do you want to do this and this and this? And I'm like, I've never done that. I'm not sure I want to do this.
Right.
But we are resistant to change. But if you don't adapt, you're going to get left behind. And ultimately, our clients will be the beneficiaries of this technology because it'll make us more productive and streamlined.
Well, also, just to jump in there and talk about, we have, since we're licensed professionals, we have a standard of care.
Right.
So, it's just like if we tried to go shepherdizing and find cases the old way, like William was talking about, we're not really living up to our standard of care. If we miss something, then, we could open ourselves up to some sort of malpractice action. So, I just see AI and legal technology moving us forward in our standard of care as well.
Mm-hmm. Yeah, that's a great point.
No, certainly. Yeah, no, I think that is a great point. I just think it's in sum from that entire episode, it's inevitably coming. I think the assistance of AI in our field. So I think it's better to be ahead of that arrival than late to the party on it, because I think you'll be doing your clients a great service by being able to utilize those tools.
Curious,
right?
Yeah, at least being curious and staying there. Well, let's pivot just a little bit and dig in to talk about preparing our arguments for trial. I think we've talked about some really general concepts, but William, I would really like to get your thought about. Okay, trial is coming. You have to prepare your opening argument. How do you start that process, and what does that process look like for you?
So we're talking about jury trials here, bench trials?
Jury
both?
trial. Or both.
Yeah, good point.
Yeah.
Good point. Good point. How is that different? I mean, I think that's a very important point.
Well, a lot of times, depending on the case, if it's a bench trial, we know the judge, or we should know the judge and have appeared in front of the judges. And some judges, they want everything. And some judges just want you to keep it simple. And if it's a bench trial, a lot of judges won't even want an opening statement, or they'll want something very brief. And so that's a different animal than the jury trial. And the jury trial, you've already gone through jury selection. You're introducing your case subtly through questions and answers during jury selection. You've already thought about, the way we were trained, or at least, and all of y'all went to Campbell, so you were probably trained the same way as I am. You start with a closing. And how am I going to close the case and hit my high points in the closing? And then that determines what evidence I got to get in to be able to put that in my closing. And the opening statement is just you're introducing subtly what's going to happen. This is what the evidence, your forecast of the evidence. And you got to be careful with that, because sometimes you may say something in opening that a judge, because of an evidentiary ruling, didn't allow in, or you through the course of it, your witness or cross-examination wasn't what you thought it would be, and you may say something in opening that ultimately doesn't come in, and the jury, if they're paying attention, and in the front end of the case, they're generally paying more attention. They get tired as they go on, but the front end of the case, they were like, well, you said that James was going to wear his red tie on on the last day, and he's never worn his red tie this entire case. That's a bad example.
That's a great point. That's a great point.
Yeah, so I'm usually one of the things I fight is being too rich and putting too much into it, and that was a criticism. I clerked for a judge, and I'd bring him an opinion that was 30 pages long, and he'd say, I want it 15, or I bring him a 15-page opinion. He said, I want it 10, and I have to follow the KISS principle, which is something else we always learn. Keep it simple, stupid. I usually just say keep it simple so I don't, hit somebody with the stupid moniker. But anyway, I fight that. I try and be more brief in my opening statement than I am in my closing statement. Just because I'm hedging my bets a little bit, but I got to tell them what the story is going to be and the main points that are going to get in.
That's a great point. James, how about you? What's your, when you sit down, okay, it's time to write. It's time to get my opening down. What's that first thing that you start to do to get your thoughts in order?
Trying to create the opening based upon whatever theme I've created. How is my theme going to play into the opening? How is my theme going to play into the closing? I mean, back to William's point, you are trying to put a closing together first, and then kind of backpedal from there. So, and then I'm thinking about, okay, what sort of objections am I potentially going to be looking at if I say what I want to say in my opening? So, I would say I'm very creative yet crafty when it comes to putting the opening together.
That's a good point. Kevin, do you use any sort of PowerPoint presentation during your opening, demonstratives? How do you handle that?
Well, demonstratives have been used. Certainly, I've never done a PowerPoint presentation during any opening statement. I'm sure it's been done, especially in your complex cases, but I think really they're certainly very effective. I've seen them more so used during summary judgment arguments. In my time in practice, where you've got a really complex issue that you need the judge to really follow, and I think that's where your PowerPoint presentations are very effective. I also think on a closing argument, when you're trying to wrap up the case and put a bow on it in front of a jury, then certainly being able to flip through slides and show them that what this and this meant is certainly what we've shown. And then from a demonstrative standpoint, I've always heard, and James and William probably agree, that one thing you always want to put in front of the jury is the verdict sheet. And we've always had those blown up to where you could go through and walk through the verdict sheet with the jury, and they can see you checking yes and no or answering questions the way you want them to answer. So I think doing that, visual journey with the jury is very important.
Yeah, I think, honestly, that's one skill I want to level up, is learning how to incorporate more, technology, as, some courtrooms allow it more than others. But, advocates that I've seen in court, to me, that's a really, taking it from good to great. What's your thoughts on that, William? Do you tend to use much technology during a trial?
Depends on the courtroom and the case and how complex it is. But yes, back to Kevin's point, I use PowerPoint. I've used it in closing. I've used it a lot more in motions, summary judgment motions, motion to dismiss, especially if it's complex and there's a lot for the judge to digest. We also blow up exhibits, and we've got Elmo, which is kind of like the old school projector that you had in class, where the teacher would put it down and work from it, or put a clear slide down so it projects up for the jurors, saves them, makes it easier for them to follow along with you. So yes, we use technology in pretty much all of our complex cases.
Right. For the young attorneys or the law students listening, how do you find out what kind of technology a courtroom might have and what you're going to be able to do?
That's a good question. We get a lot of vendors that reach out to us, and then we've, kind of monkey see, monkey do. We've been in cases where other folks have used technology, or our co-counsel have used technology, or even opposing counsel have used technology, and we're like, wow, that's neat. I want to use that. And so it's, the ideas get spread out and word of mouth, and we have a lot of good associations with several top-rate attorneys across the state and the country that we've learned things from, and they've learned things from us, which is the give and take of some of our associations that we've had over the years.
Well, and every lawyer, Misty, has the fear of, I want to utilize this technology, but we get in there and it doesn't work. So you look bad as the lawyer because you're wasting everyone's time. The jury's looking at you. You're trying to get everything prepared. So that's the one thing that especially young lawyers you need to overcome, because when it does work properly, it is so much more efficient. I mean, William talked about the Elmo. If you have a document intensive trial, having that Elmo right there where you can, put a document on, it blows up where the jury can see it, and they can see what you're talking about. It is so much more impactful than you simply having a deposition transcript and you're reading from it and no one's paying attention or reading along to what, you're talking about. It has a much bigger effect. So if you have the technology capabilities and you have especially a document intensive type case, use it. I mean, I know it will be nerve-wracking because technology sometimes does not work, but I'm telling you, use it.
Well, and I think you can have some redundant systems there in the beginning to make you feel a little bit more secure. You want to use the technology, but sometimes just having the backup, unfortunately, paper can kind of set your fears aside. It allows you to expand and use that sort of technology. But I agree, it's really helpful, especially to juries, to be able to look at the words and talk about them. So I want to talk to you, William, about, you started out practicing law and you've been doing it for so many years now and you've become really experienced. How has your advocacy style transformed? And was that intentionally, or is it just a factor of doing it so many times where, you just get comfortable, get that self-confidence and improve your skills?
There's obviously that. I mean, the experience, and the more you do it, the easier it is to do it. I can remember my first argument. Gary walked into my office and said, "Hey, summary judgment, 2 days. Here's the file. You got it." And I was a new associate, and my heart was beating 1,000 miles a minute. I even went running. I took a jog at lunch before the afternoon hearing to try and settle myself down. And ended up, it was summary judgment against us and ended up winning it. And, it's just, make my day. But I was so nervous. And the judge, it was Judge Hooks, who was a great judge from Columbus County. He was very kind, and, I might have even told him, "Hey, it's my first hearing. Please bear with me," try and take the sting out of it. But, I've probably done a couple hundred since then. So, I don't keep track of them. But anyway, the more you do something, the better you get at it. And the biggest thing about any argument you have is you got to be prepared. You can't just go in there and wing it, because if not, you're going to get chewed up by opposing counsel or the judge. And, so the more you do something, the better. And watching good attorneys. We're fortunate. We've got great attorneys in this firm. I've learned something from everybody. I mean, new associates, Gary, I've been practicing with since 2000. He's taught me a lot. Like I said before, we've had a lot of great associations with big time firms all across the country. I've been fortunate to do that. I also clerked on the Court of Appeals in 99 and 2000 before I came between law school and coming here. And that was an incredible education, because I saw the best of the best and the worst of the worst. Yeah. And so how not to do it as much as I did, how to do it. Appellate advocacy is a little bit different. You got to make all your arguments in 30 minutes at the North Carolina Court of Appeals and the Supreme Court, whereas in a trial court level, judges tend to give you a little more leeway. Some judges will put time limits on it, but you just over time and stealing things from other attorneys and learning things from other attorneys.
I've got a question, William, about your former background being an educator. Mm-hmm. How does that influence at least your style of advocacy? I mean, Kevin and I, Misty, we talked in the past about, some are preachers, some are teachers, some are storytellers. Do you think, or do you find it, being a former educator, do you find that influencing the way that you advocate something, whether it's a hearing, whether it's a trial?
Mm-hmm. Yeah, for sure. As James mentioned, I taught school in the past, and the way I taught, I remember one of my professors at School of Education at UNCW, Watson School of Education, which is a great school. I taught as a storyteller, and I didn't even realize it. I remember my first critique from the professor. He said, "Oh, great! I like the way you tell the story to teach the lesson." And I was like, "Did I?" And so that really comes into play in jury trials because you got 12 people in the box who don't know anybody other than the case, and so you have to kind of teach them what the case is about. And back to your point, your theme, you underline your theme. What's going on with the jury, and a lot of times with the judges, you're also educating them about what's your case about, what the legal issues are, what the cases say, and what the lessons from those cases are. And so it's all a process of back to what we were talking about here, education and teaching and storytelling. That's really what it is. With a jury, it's a little more dog and pony show than a judge. Fortunately, it's never happened to me, but I've heard horror stories of judges saying to attorneys, "Don't make a jury argue to me. I'm not a jury." So it's a little more clinical with a judge, especially if you've got an older, experienced judge they've heard all these arguments. They know the standard of review and the case law better than you do a lot of times. But there's some storytelling and teaching to it for sure.
William, when we talk about voir dire, I think that can vary greatly too, according to your judge and, whether you're in federal court, state court, how do you prepare for voir dire? And really that's your first step in your persuasive journey. Of course, your first step is probably to figure out your judge and see, how extensive you're going to be able to question. But, what are you thinking about when you're preparing questions for potential jurors?
We do research on the juries a lot of times and try and see, do we know anybody, or does the other side know anybody, or, and do some research on who your audience is. And then secondarily, or primarily rather, we want to make sure that figure out who's got biases, because both sides are trying to select the best jury for their case. And so there's a little bit of gamesmanship going on there. You have a certain number of peremptory challenges, and then you have challenges for cause. Typically those challenges for cause, meaning they know somebody or there's a bias or blah, blah, blah. Those are more infrequent. But the peremptory challenges means I'm going to strike up to 6 strikes. Sometimes it's less than that, depending on the judge. And you're trying to figure out the jurors who aren't going to be good for you and how to get them out so that you've got the best jury for your case. But the other side's doing the same thing. Federal court, the judge runs the show. You're trying to help with the questionnaire for the jurors. But
what's your name?
Exactly.
Judge, you want some water, Judge?
Exactly. You're not. Federal court's a totally different animal. You might as well just blindfold yourself and say, "Go ahead, Judge."
So as you're proceeding through voir dire and you're getting to the point, as you mentioned earlier, where you're trying to introduce your case through jury selection, what sort of techniques are you employing? I've seen people that will one by one say juror number 7, all the way down through jurors. I've seen some that will say, show me your hand by raising hands, do this. I've heard some people will come and sit down in a chair in front of the jury and just have a story time with them. So what sort of things do you do to kind of tease out those sort of issues that you may or may not want on your jury as you're proceeding to trial?
I try and get them talking. That's the main thing. And the best thing is where the group talks and you're not talking, because if you ask open-ended questions, you're going to get open answers. If you ask yes or no questions, you're going to get because people naturally, most people don't want to speak in front of a big audience of people that they don't know. And so you try and get them talking, you try and subtly introduce your case. And I'm back to your point. I like to sit in front of the jury and have a discussion with them, and try not to offend anybody, because sometimes the questions can be probing.
They're tough questions sometimes.
Yeah, they're probing, and it's a fine line, and it's an art. Every time I pick a jury, I learn something new, and try not to. I just try to do the best you can in a bad situation, because you really, and a lot of times people aren't being fully honest with you. And a lot of times people are just trying to get out. They don't want to be there. That's one of our problems. It's a limited amount of money. You got to spend your time. Right. You're missing work. They'd rather be anywhere than being, unless it's like a retiree who watches court TV all day. They don't want to be there, and it's a tough road to hoe. But
I interned while I was in law school for John McCabe, who was another really good trial attorney, and he made a good point when he was talking about voir dire with me. Is he goes, that's my first opportunity to get the jury, that member, to like me, to develop a rapport.
I was going to say the same thing, is try and get them to like you, and if you can have some self-deprecating humor, I usually put that in there. There was a funny story one of my professors told, that they grabbed the lectern and walked up and were going to start talking to the jury, and the judge says, you can't take the lectern. He said, well, I won't do that. And the jury laughed, and everybody in the room laughed, and they loved him. And from that moment on, so that's back to get the jury to love you, and don't be a butthead during those questions. About we had a case one time where opposing counsel was very abrasive, and he turned the jury off from jury selection all the way through the entire case, and we ended up ultimately winning the case. Well, it's settled before, but the writing was on the wall. And we settled for less than what we offered at mediation, because it was so clear the jury didn't like the other side, and they wanted to get out, for that. But that's...
James, what sorts of things do you do to sort of captivate and capture the hearts and minds
break the ice, Kevin? I go in there like, don't worry about the judge and the bailiff and the audience and everyone sitting here talking to you. It's just you and I talking. Everyone usually laughs because they're like, no, this is a stuffy room. So anything you can do to break the ice, let them know that you are human. Right. You're probably nervous as a lawyer. Because they're going to be nervous. So just embrace that and make it a situation where they are as comfortable as they can possibly be. Because that's when you're going to find out who these jurors really are. Right. That's the only way. So.
Well, I want to talk, I know, William, you handle a lot of products liability cases. So I want to talk a little bit about some nuances with those types of cases. What do you think is typically the most challenging aspect of a products liability case?
The science, a lot of times, that's one of the most difficult cases I wrote or helped write. My judge wrote it. He was the one when I was clerking on the Court of Appeals. Can't remember the name of the case right now, but it was dealing with both negligent manufacture and breach of implied warranties, and very difficult, both case law and the science behind that case. And this was a developed record that had come up to the Court of Appeals that the judge and I struggled with. Normally it would take me we'd have court every month and you'd have at least 4 opinions to write. So I would average like 1 opinion a week on average. And I remember it took us like 4 weeks to write that opinion because there was so much to dive into with, number one thing in a products liability, you better have a great expert.
Yeah.
Because, you're getting into, it's not did they run the stoplight or were they speeding or, it's not something that the average juror is going to have knowledge about. And so you better have a good expert who is going to present well and is going to stand up to cross-examination. So that's the starting point. We'll get cases in, we'll review them, and we'll say, oh, this looks like a good case. Now we got to find the expert. And then we go find the expert. And, if statistics mean anything, the majority of our cases get kicked because the expert says, this is not a problem or this is a problem or, for a variety of reasons. But having a great expert is the most important thing in a product liability case.
Is that the same? Would you say that's sort of the same issue? Well, I guess it would depend. But when you're dealing with class actions, because you've got a lot of experience with class actions as well, is that another thing where you're really largely expert dependent, or are you more so just?
Depends on the class action, but yeah, a lot of our class actions have been product related or representation related, and so you need the expert to tell us whether there is something wrong with that product or whether the representations that were made regarding that product were false or deceptive or things of that nature. But you got to have the experts.
James, why don't you explain to the audience the difference between, general causation and specific causation and how, it can play into some cases and the nuances of that.
Put me on the spot, Misty.
I mean, I don't think you know who you're talking to, Misty. He's got to look at it on the computer screen first, Misty.
This is long-winded. General causation, I mean, anytime you are talking about, I'll take it like a medical device type scenario. It's the general causation is going to relate to essentially every claimant. What caused the injury, not the specific underlying injury, but what caused the injury as a whole. So you have general causation experts that speak to that every claimant can utilize the general causation experts. Specific causation, you're looking at the specific individualized injury of a particular claimant, and you have those experts identifying, for the specific causation, okay, this was the issue, and this specifically caused the injury of this individualized claimant. I know that's a lot to say in a little bit, but I mean, essentially that's what it is.
I thought it was good, James.
No, that's good. It's good. So when we talk about, Kevin, establishing general causation, is that if we're in a class action, once we've established that, it's going to apply to each individual claimant. Is that correct?
Right.
That's right.
Right.
Okay. So it's very important to get a great expert to establish that general causation, because, that's really your first step in the door.
Yeah. Now, aside from the substantive issues, what about sort of the just procedural, issues that you have when you're attempting to certify a class? How do you sort of ensure that, the numerosity, the typicality, the predominance, all that stuff is not going to be an issue as you're trying to make your way through to getting certified?
If only there was a black and white answer to that, William. I can't wait to hear this answer.
So class actions are they're a different animal because normally you have, plaintiff A suing defendant B,
right,
and is defendant liable for that. In a class action, you have to show, and this is very general, you have to show that your plaintiff is a good representative for the class, and their injuries or damages are common and typical of everybody else in the class. And those claims predominate over any individualized issues. Sometimes it can be as simple as, a violation of a statute, and the defendant violated the statute across the board to several folks. And the commonality, the typicality, the numerosity, the adequacy, and superiority are the touchstones of it. Commonality means the claims are common and typical, and they kind of overlap with everybody in the class. The adequacy means that you've got good counsel and there's no conflicts of interest and between the class representative, the class counsel, and the rest of the class. Like there's no claims against them or nothing that sets them off that's gonna distract from them being a zealous advocate, because that's what they've got to do as a class representative, and we as class counsel. The plaintiffs can't be treated differently than the class. If every claimant in the class is entitled to $1, you can't pay the class representative $3. They have to get $1 for $1 or the same percentage across the board. And then the predominance means, okay, if we resolve this issue, it predominates over the whole case. And it doesn't necessarily have to resolve the case. Sometimes there's issue classes where you're shortening the putt and there may be a mini trial for the class reps afterwards.
Right.
And then the superiority means it's better to try this at one time than to do it, say if we've got 75 class members, 75 times. And then, so I think I've covered them all: commonality, typicality, adequacy, predominance, and numerosity. So numerosity, that's a moving target. That just means the rule is it would be impracticable to join everybody and have them in the lawsuit. So there's no real number. I think Newberg, who's the guru on class action, says anything over 40 is fine. But really, I've seen class certified as small as like 14, because you don't want to have 14 plaintiffs sitting in the courtroom and dealing with that when one person could do it, especially if it's across the board.
And potentially getting different remedies. I mean, that's one of the things that it tries to balance, that everybody's going to get a similar remedy.
From a negotiation perspective, if you can find yourself on the other side of being certified, does that at that point in time, in your experience, sort of lend itself to the defendant being more likely to want to enter into some sort of class settlement agreement or mediation or early mediation to go ahead and resolve, because at that point the writing's on the wall that you'll likely be successful?
Depends on the case. Some defense counsel will fight tooth and nail all the way through class certification, and every issue, is a hill to die on for them. Sometimes it's better, develop the case, get everything where you feel like you understand it, and we can go through mediation before it is even certified, to try and resolve it on a class-wide basis. And then you've got to go through the approval and everything else that happens after that. But it really depends on the case. I've certified them and then settled them. I've settled them and then certified it as a settlement class. It's it really depends on how hard defense counsel is going to fight. And sometimes, depending on where you are, some federal districts, you're required to move for certification within 90 days unless you move to extend it. And so there's some really short time periods, and you just got to go ahead and move for certification if you can early on.
Good point. Well, okay. Well, it's time for the Zealous Advocate Law Review. And so today we are going to be doing cologne.
Or perfume.
We'll call it fragrance because we're being inclusive. Fragrances.
And so we have to give a pitch. We're going to be persuasive today. And James, are you ready to go first?
William, are you participating in this?
I hadn't planned on it. I'll be a judge.
Yes. I appreciate Mr. Wright being a judge today, because these people on this podcast are clearly biased.
Wow.
Clearly. But Misty, I thought you were going first. I went first. James went first one time. It's on you.
Well, look, I've already told you guys I don't wear perfume. So I'm just going to need a few minutes.
Okay.
On this.
Okay.
So I'm going to let you
James
guys
can go first.
You want me to go first?
Yes.
Yeah.
And go first correctly.
What does that mean?
You know what I expect to hear first and foremost.
Okay. This was a gift
It was.
from Mr. Littlejohn himself a while back, and you see it's barely been used. So Misty, back to your point, I hardly use cologne. So
Terrible.
this is the Coach Blue 3.3 ounce cologne, where a subtle splash can make a lasting impression. It has the ability to spark cherished memories, trigger uncontrolled emotions, prompt an instant attraction, and even provide confidence when it's needed the most. Whether it's a wedding, an interview, a job, a meeting, a party,
You're losing it.
or even your very first date, Kevin, whenever that may be.
Oh,
Let the Coach Blue 3.3 ounce cologne be the first impression that leaves a lasting impression. It speaks volumes without saying a word.
You got that country McConaughey thing at the end where it's like speaks volumes without saying a word. I'm like, all right, dude.
Got a
he
little
does
tripped
go
up, but it's okay.
McConaughey on
Yeah.
a
Okay.
lot.
Is it you, Misty, or me?
All right.
Right.
You go ahead, Kev.
Tom, leave me right here. I want the full screen on me because I want to really.
Oh, my goodness.
Oh Lord,
Thank you,
You
Tom.
used to like seeing everyone else. Now you want to just see yourself.
that's Kevin.
What I've got before me, and before I begin, Mr. I do these. I talk just to James on these because he needs to understand what I'm doing because you'll miss it if you don't pay attention.
Oh, here, right? Wow.
Well, then it's not that good.
What I've got before me, James, is the Bond number 9 Sutton Place fragrance. It's amber vanilla. It's been said that to hold one's senses captive is to control their entire soul. And with this fragrance, that's exactly what you will do. It will leave your company anxious to be your company once again. Bond number 9, Sutton Place at a local Ulta near you.
I like that.
Leave your company anxious to be your company again, James.
I like that.
I mean, that's a good line.
It is.
That's a
It
good
is.
line.
I like this. All right,
right,
Misty, let's
Misty.
hear it.
On you.
Okay. Well, look, and I'm going to give a backstory right quick. So I don't wear.
Here's the
perfume
cop
anymore
out.
because
This
gives me headaches.
this offends the spirit of this competition to do this. What you're
But-
doing right now, Misty.
No, listen to me. But I used to wear Clinique Happy Heart, so I'm going to pitch that because I always love that fragrance. Okay. All right. A woman's essence makes her feel special. She derives her power, her self-confidence from how she looks and feels. That power is enhanced by Clinique Happy Heart. That's all I got.
I like it.
guys.
I like it. The mere essence. I love it.
I like how
I
we're
love
getting,
it.
I like how we're getting short and sweet.
Yeah, I
on
like
this.
how because everybody's starting to see now it's going to be short and sweet. I will get us sponsored by Bond number 9.
So
Oh.
is Bond related to James Bond?
No, it's actually New York NYC. It's not related to James Bond at all. I don't know where the Bond came from, but they've got some really good fragrances.
We
I
should
really
go on
like
a field trip and go smelling fragrances and see what we like. That would be fun.
After a while, my nose,
Yeah.
when you go to like the counters at Belk's or wherever, it's
They
the
start
second
off
or
smelling the
third
same
one,
to
you
me.
need-
I'm like, dog.
yeah, you need the
Yeah.
the wine taste in the water that you spit out so you can figure out. Well,
Yeah.
Well, Mr. Wright,
what's
you've
your
got
go-to
to
cologne,
Yeah, what's
William?
your go-to cologne?
it's I think it's Aqua Dulce.
Oh, Aqua Dulce.
My wife
Oh,
bought it.
a little Italian or Frenchman, whatever is that? What is that?
Sweet
okay.
water, sugar water, something.
All right, you got to pick a winner. You got to pick a winner between us three. I already know what you're going to say. You're going to choose Misty.
All three of them were great, and I was going to go between you and James, Kevin, and I don't know. That's why I asked for the fragrances. That was going to be my tiebreaker, but I like both of them. But I think
hold on. We got to hit. No, he's got to choose one. He's got to choose one.
Oh, you're insane.
I think I'm gonna go with McConaughey today. I'm sorry.
All right.
Oh, he was laughing and stumbling over everything he said. No,
it was not the presentation as much as the message.
I appreciate that, William. It is. See,
I'm over here.
William sees what the words are saying.
That is outrageous.
You can mess up on
I'm not going to that concert with you on Thursday. We're not going to that concert together anymore. I offended our friendship.
So personal. All right. I'm because of the emotional reaction, I'm going to go to Kevin now. The judges have really done the ruling.
And you see why, William, we keep trying to well, Judge, just give me a second.
Exactly.
I can convince you otherwise.
Yeah, reconsider.
McConaughey is one of my favorites. So going McConaughey was.
That was good.
Yeah.
Okay, Kevin, why don't you wrap us up for this episode and take us home?
Certainly. Thank you. This is my first time doing this, so I will certainly embrace this. It has been a pleasure, Mr. Wright, to have you join us down here on the Zealous Advocate Podcast. We certainly appreciate you taking time out of your busy schedule to not only enlighten our listeners, but enlighten us on the various things you've learned throughout your illustrious career. We look forward to speaking with you again and look forward to working with you for the foreseeable future.
Absolutely.
As always, join us, like us, subscribe to us on the various platforms, Spotify, YouTube, Apple Podcasts is what Tom just told me. So we've got a lot of platforms for you all to gain this knowledge and information as we take on this journey to becoming the best zealous advocates we can be. And we look forward to seeing you next time. So long.
Does Tom get any face time?
Not at all. Not at all.
Thanks for tuning in to the Zealous Advocate Podcast. Make sure to subscribe to follow us wherever you get your podcasts.